The webinar will begin in 1 minute. Welcome everyone. Thanks for joining us for today's webinar entitled Business Buy-Sell Litigation Over Mismanaged Funding. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Suchis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning practice in Franklin, Tennessee. Linus also publishes Think About It, founded by the life insurance industry guru Steve Limeberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available for sale.
Thanks, Jennifer.
And here he is.
Yeah, thanks, Jennifer. I appreciate it very much. Hello, everyone. Glad you joined us today. We're going to talk about 3 court cases in which the buy-sell funding, at least from our perspective, was mismanaged. And I think those cases provide some valuable lessons for those of us who work with business owners with regard to buy-sell planning and with regard to life insurance. There are 3 cases, and so we can't really do them justice in just the 15 or 20 minutes that we have together. So I'd really encourage you, if you have an interest in learning more about them, to ask for the materials, and Jennifer will explain how to do that at the end of today's session. Obviously, these cases have some errors associated with them, and the main lesson for those of us who are in the businesses, don't follow that example, right? But we're gonna talk more specifically about how they were screwed up. But before we get into the meat of the presentation today, let's talk about what it is that we will talk about next month. You're going to have 3 choices with regard to next month, and you can vote in the poll. But the 3 choices are, first of all, the ethical issues associated with working with incapacitated clients. The second choice is captive insurance arrangements. They took another hit, and we would talk about that in more detail. And then the third choice is something we haven't done before, which we thought might be of interest to some attendees. It's a live question and answer session where you can ask live the questions that have been bugging you, perhaps about existing cases or just questions that have been bugging you in general. And then Jennifer and I would deal with them live on the webinar. So I am going to open the poll. Let's say I'm going to open the poll. I'm going to open the poll right now and ask you to vote in the next 15 seconds or so. Please go ahead and vote, and we will decide on what we're going to deal with next month. Most folks have voted. If you haven't voted yet, please just take another quick second and enter your vote. All right. Thank you all for voting, and the winner is live question and answer. We'll do a live question and answer session for next month's webinar. Thank you for participating in that. So let's go ahead and get started with our content for today. So in the way of quick background on buy-sell planning, of course, our business owner clients rely on their businesses for a lot of things. A successful entrepreneur's business provides income for the owner's family. They support the family of their employees if they have employees, and there's an opportunity to leave a legacy for a family business to other members of the owner's family. In many cases, a properly drafted, implemented, and funded buy-sell agreement can achieve some of those goals. It's not right for everybody, but the buy-sell agreement, properly funded, can be a tool to achieve those goals. And where a buy-sell is called for, a buy-sell agreement is called for, if the agreement itself is badly written or if the buy-sell funding is mismanaged, the plan won't work. It could end up in litigation, like the cases we're going to talk about today, and that can be a disaster for everyone involved. And even if the arrangement is correct at the time that it's put into place, folks need to pay attention to it along the way because circumstances change and people need to be sure that the objectives are being met. So what's our role in this? Our role as life insurance professionals is to provide the funding, and we often defer to the client's attorney with regard to the buy-sell agreement. But we have to work successfully with the attorney in order to make sure everything hangs together. We're going to talk about some cases where that didn't happen today, and the lessons that we're going to take, and I guess we're cheating in advance. The lessons from the cases are to be clear in the buy-sell agreement about what it is that's intended. The second thing is to review the agreement and the funding regularly to make sure they are still effective, and make sure that the agreement and the funding properly reflect changes in circumstances as we go forward. So let's make sure that, or let's get started with the first case on the list, the case of Lynn versus Lynn, which is a North Carolina appeals court case from 2010. Under the facts of Lynn, we've got a multi-generation business, or a two-generation business. We've got Dad, James Lynn, owning 51% of the stock in James Lynn and Sons, and we've got each of the kids owning a 24.5% share in the business. And in 1993, the three owners and their spouses entered into a shareholders agreement which has these words in them. The words are, upon the death of any shareholder, the estate will sell and the corporation is going to buy. So it looks like entity purchase, buy, sell. It also has words in it that say purchase value means that life insurance proceeds in an amount of not less than $75,000. And those words are taken directly from the agreement. And you'd think that adding more words after the 75,000 would make it clearer about what it is that they intend, but they really don't. what I think this means is that the ownership interests of the two sons are worth 75 grand under the buy-sell agreement. Not entirely clear, and it's one of the things, or one of the peeves that we have about buy-sell planning is when the agreement isn't drawn up precisely. It can leave a lot of room for the parties to be arguing after the death of one of the owners. So in any event, that's a nit that we're picking here. Let's talk about what happened in the Lynn case. So prior to the execution of that shareholders agreement, the two sons had each purchased 75 grand of life insurance money, of life insurance coverage on each other. So it was funded as a cross purchase, even though the agreement language seemed to say that the obligation was an entity purchase. So there was always already kind of a mismatch between the funding and the agreement. So Dad dies in 1997. The corporation doesn't own any insurance on his life. His wife, who's the two surviving owners, the son's mother, inherits James's 51% interest in the business. And in 2001, some 4 years later, Gregory and Kenneth enter into an agreement with their mom to buy her out for $100,000. So the two brothers are now the owners of the business. What happens next? In 2001, the two brothers buy additional insurance on each other. The total coverage amount is now $375,000. That is cross-owned. At some point during that year, the brothers switch the ownership of the policies, and the insured now becomes the owner of the $375,000 of coverage on each brother. So the insured owns the policies. The buy-sell agreement is still written as an entity purchase arrangement. If you're following at home, it's getting more and more complicated, and it's going to get even more complicated still. So Kenneth, the one brother, names his wife the beneficiary. Gregory names his kids as the beneficiary of his policy. And the corporation pays the premium for the policies, but neither Gregory nor Kenneth ever include the premiums as personal income. Those of you who are active in the business market know that's an issue as well, but it's not an issue that the court deals with in this case. It's just kind of an interesting aside. So if it weren't already complicated enough, Gregory's wife files for divorce in 2003. She asks the court to decide how to equitably divide their assets. The buy-sell agreement says nothing about what happens in the event of a divorce. In 2004, Kenneth and Gregory negotiate, Kenneth becoming a 55% owner while Gregory becomes a minority owner. And Kenneth fires Gregory. So there it's gotten more complicated. So the divorce is finalized except for the property division. And then Kenneth dies, right? Kenneth's now the majority owner and he dies. Gregory, who's in the process of going through a divorce with Jan, and they're dividing up Gregory's ownership interest in the business. He's now in line to own the whole business, which Jan rightly tries to take advantage of, saying that now she should get half of the whole business as opposed to half of Kenneth's 45% interest, or Gregory's 45% interest in the business. And so so Kenneth's widow wants to collect not only the insurance proceeds but extra money for the buyout of the shares. So you've got basically three sides that are part of this litigation, all of whom want money. Penny wants to keep the money, keep the ownership interest in the business, so the trial court is asked to sort it out. The trial court recognizes that there's ambiguities, in the shareholders agreement, and whether or not the buyout was supposed to happen in the event of death and what role the insurance played. was not directly addressed. Jan and Gregory say that no, Gregory now owns all the shares that Penny needs to turn the shares over. She's already gotten her money from the life insurance policy. Penny says, no, that's not the way it should be. And what does the trial court say? The trial court looks to the evidence and looks at what was told the insurance company when the newest policies were taken out. The insurance company was told that the coverage was for buy-sell coverage, and so that helps solidify the trial court's conclusion that that Penny needed to turn over the shares that she got her money that the insurance was intended to effectuate the buyout. The trial court decides that Penny needs to turn over the shares, and the North Carolina Appeals Court affirms that judgment. And it's so much harder than it needed to be. Clearly, the parties didn't pay attention along the way. There was much that was done incorrectly with regard to both the insurance structure and with regard to the buy-sell agreement. One would hope that the agent did not help the parties continue down the wrong path, that if the insurance agent was involved, they could have done it right. So that's the first case. Let's move on to another case, which is a case from the western part of the country, Baker and Ayers versus Baker, Poland Post. This case is about a sawmill where two couples get involved with putting together a sawmill to own and operate. They execute a stock purchase agreement that in the event something happens to either one of the two husbands, that the surviving couple will buy out, and they contemplate the probability that life insurance is going to be owned by the two husbands by the company, and the company is going to be the beneficiary to provide the money to make the buyout happen. So what happens facts-wise? Before the formation of the company, Ayers buys a life insurance policy naming a prior company as beneficiary. In 1990, again, before the formation of the company, Baker bought a life policy in which he named Mrs. Baker as the beneficiary. The company was never, the new company was never a beneficiary of Baker's policy, and Baker never transferred or assigned his policy to the company, and the company never bought coverage. So in 2000, Baker dies. Mrs. Baker gets the benefits under his life insurance policy. She wants to keep the money and make the company's stock her own, perhaps selling it at its value of 719 grand. The heirs say that no, Baker's life insurance policy was intended in part to fund the buyout. You got 500 grand, we only owe you 219 grand, which is the rest of the value of the stock, and you'll need to turn the stock over to us. So the parties end up in court. Mrs. Baker says that she's entitled to keep everything because the company doesn't give her the 719 grand she demands for her shares. She files a complaint in the court saying, hey, you breached the stock purchase agreement. The heirs assert their petition that the Bakers should have named the company the beneficiary on Mr. Baker's policy. The Bakers held the insurance policy effectively in a trust for the benefit of the company. When Mrs. Baker kept the 500 grand, she should have surrendered her shares and only been owed $219,000 plus interest. And that's where the parties stand. And in the trial court granted summary judgment without a trial in favor of the heirs, basically saying that the policy should have been counted toward the buyout price that Mrs. Baker aired in just keeping the money and demanding the rest of the full $719,000 buyout price. So Mrs. Baker appeals to the appeals court, the state appeals court. You get some testimony, get some information from the insurance agent, and finds out that Mrs. Baker had submitted some evidence that the policy was needed to secure an SBA loan, and that Mr. Baker had told her that the policy was personal, that it was being paid for out of his regular wages, and that the buy-sell would be funded with a separate policy. And the court says, well, the trial court didn't really consider that evidence, and so the appeals court sent the case back to the trial court and directed it to try to figure out what the parties actually intended. The appeals court said the trial court decided the case too soon without sorting out enough of the evidence. And so that's a 2005 case. It's unclear how the case was actually resolved. The parties probably settled it without further court involvement, but certainly the process was expensive and uncertain, and that's not what the parties intended when they entered into a buy-sell agreement. And so let's go to the third case real quick. We've got the case of D3 Interiors. We've got Ohio National issues an insurance policy to a company called IDF with Charlotte Dan as the insured. It's a disability buyout coverage. If Charlotte becomes disabled, the policy will pay out. The policy has a provision in it that says you've got to have a buy-sell agreement in effect for the payout to be valid. If there is no buy-sell agreement in effect at the time of the triggering event, the company, Ohio National, is going to treat the policy as if it has never been issued and is just going to return the premiums. And so as part of the application process in '96, the lawyer faxes an executed copy of the shareholders agreement to Ohio National, and the policy is issued. Well, in 2005, Charlotte leaves the old company and forms a new business with her daughters called D3 Interiors, and they subsequently asked to change ownership on the Ohio National policy to her personally. Ohio National rejects the request, and so because the policy needs to be owned by a business entity, and so then they request that the ownership be in the name of the company. They resubmit the application. Ohio National accepts that change of ownership form. D3 starts paying the premiums. The policy, of course, has this provision about the buy-sell agreement being in effect on a new business entity within 1 year of the transfer. And so the buy-sell agreement for D3 wasn't furnished to Ohio National when ownership was changed, and a written buy-sell agreement, of course, was never executed by the shareholders of the new company. So the members of the new company, the shareholders, say they had an unwritten understanding for a buy-sell in the event of the mother's death or another triggering event, and that was their position after the case started being litigated. And D3 starts undergoing some financial issues. Charlotte stops working at D3. She's depressed. She attempts to commit suicide, and later on, she's determined to be completely and totally disabled. And so her daughters put in a claim for benefits under the Ohio National policy, saying that the depression was disabling, and they're seeking the buyout funds, the disability buyout funds from Ohio National. Ohio National asks for a copy of the buy-sell agreement, and of course the parties cannot produce a formal written buy-sell agreement. So Ohio National denies the claim. Of course, the parties think that Ohio National should pay the claim. D3 files a lawsuit, says Ohio National continue to accept premiums and thus should be on the hook. And Ohio National says, asks the court to rule for judgment as a matter of law based on the facts that it doesn't have to pay out the benefit. And the district court grants that, and the decision is affirmed by the appeals court. Those are really quick summaries of those three cases. What are the big lessons from the cases? I think the first one is to keep in touch with your business owner clients. Here, a lot of stuff happened after an initial buy-sell agreement was drafted and funded, and there wasn't enough attention paid to the details along the way, and the parties ended up in litigation. And so the first big lesson for us from the cases is keep in touch. Second big lesson, I think, is to work together as a team. Lawyers don't know everything, despite the fact they'll try to tell you otherwise. So working effectively together with lawyers and accountants on the client's team to make sure that everything is working together is really, really important. And that's really how we can serve our clients best, is to work together as a team. And if there's existing insurance that's intended to fund a death time or a disability buyout, make the transfer as soon as possible. You know, if there's new coverage, that's one thing, but if there's existing coverage that needs to be transferred, I think it's up to us to help make sure that our clients do it and do it in a timely way. So all of those are lessons from the cases, things that could have gone better if those things were paid attention to along the way. What other things might we learn from the cases that are perhaps bigger issues? First of all, our business owner clients expect us to give expert business and insurance advice. The cases we've talked about today have some lessons for us and for our clients. And so I think when we're working with our clients and thinking about working with our clients, we should be asking ourselves the following questions. And the first question is, if we'd acted as advisors to the business owners and their families in these particular court cases, what could we have done better than the things that actually happened? I think that's the first question. Second question is, how many of our current clients are in similar circumstances where they've got problems that have come up where perhaps we don't know about them, or perhaps we do know about them where the clients haven't reacted properly yet? Because a problem is only a heartbeat away, and after something happens, that might be too late to fix things. New buy-sell case litigation is being filed every day. This is a warning to us to stay vigilant and an opportunity for us to serve our clients better. So let me at this point stop. Thank you for attending. I would like to turn the program back over to Jennifer, who can explain more information about today's session and how to get more materials. Jennifer?
Thanks, Linus, and thanks for joining us today. If you would like to receive supporting materials about today's presentation, please email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email us questions related to today's webinar. And finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultations and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.